If you're looking for a car accident lawyer in Orlando or really anywhere in Florida, you may have been told that the attorney's fees are 33 and a third, or possibly even less. That's unlikely, but you may have been told that. And lawyers aren't telling you the whole story in most cases if they tell you that it's 33 and a third. I'm Tina Willis. I'm a personal injury and car accident lawyer in Orlando, Florida. We do handle cases all over the state, including catastrophic injury and wrongful death cases, but also any moderate injury case. For minor injuries, it's probably not even worth you having a lawyer, but I would encourage you not to decide for yourself about the seriousness of your injuries, because some people think that there's not much wrong when their back and neck is messed up, and then they only realize later that they really do need more significant treatment or they're hurting more than they thought. But let me get back to the fees. So the way fees work in Florida, I think a lot of lawyers won't explain to you in the depth that you really deserve to know. The reason this came up is because I had a client last week asking about our fees and being confused because he had been told something else from a different firm. So let me just jump right in. Florida, I would like to do a screen share right now, but it's too technically complicated. But you need to know that Florida lawyers are governed by something called the Florida Bar Rules. I've got the Florida Bar Rules open on my laptop right now. They are 262 pages long. But there's a section that deals with the rules that contingency fee lawyers can charge. And contingency, is different from, for example, hourly fees or flat rate. Different practice areas charge fees differently. So if you had like a contract dispute with a business, then most likely you would pay fees by the hour or possibly a flat rate. But for car accidents and any type of injury case, we charge based on contingency. And that means that you pay nothing unless we recover money from you. That's true with all injury lawyers, so it's not like some trailblazing thing that any particular firm is offering. You've probably seen that everywhere, and you can get that everywhere. But what's different is, what people are told about the fees and whether they get the full explanation. So the rule that governs these type of fees under the Florida Bar Rules is Rule 4-1.5, which is fees and costs for legal services. I think this is available to consumers if you wanted to read it. I'm not entirely sure. I access this through the Florida Bar website. But there's a section, it's got a lot of subsections that we can't charge clearly excessive fees and costs, factors to be determined in determining whether costs are reasonable. Fees and costs are reasonable, but that doesn't really apply in this particular situation. Those are more about hourly rates, and sometimes courts award attorneys fees, and there are factors that go into that. So we don't worry about any of that. I'm moving down to where I should have started, which is section F, subsection F is on contingent fees. Now, this rule is multiple pages long, and it's going into the notice that you have to be given. Like, this has to be written into a statement of client. Some of this has to be written into a statement of client rights. We also have to have this in the contract spelled out, which it should be. However, I'll tell you later about a fee contract I saw that kind of blew my mind a few years ago, which can also happen. In other words, it did not have this rule spelled out in it. And I'll tell you how they got around that. But I don't want to digress too much. The actual rule, let's see if I can hold this up and make sure nothing that I can't show is on the screen, like privileged or anything, but I've got the rule held up right there. So you can see it's a real rule. But it's got multi-factors, depending on really the amount that you're possibly might recover, and then the stage of your case. So for a lot of people, really what's going to be the determining factor is the stage of their case where they reach a settlement or get a jury verdict. But there are, for super high value cases over $1 million, there is a step down fee process, and I'm going to make another video on that. I'm not going to cover that during this because I feel like it would get too complicated. So the deal is that if, again, in car accident, truck accident, any personal injury like slip and fall or any other kind of injury, all of which we handle, if we have not filed a lawsuit yet, or even if we have filed a lawsuit, if the defendant has not answered that lawsuit, then the fee is 33 1/3. So what that means, so technically the line before the fee goes up is when the defendant answers the complaint. So the way lawsuits work is that we walk down to the courthouse, we file a document called a complaint. That's what initiates a lawsuit. We do some research and stuff. It's written out. It might be 5 or 10 pages long in a typical car accident case. I mean, I've seen complaints that are 50 pages long. They're numbered paragraphs with allegations of what happened in the case. Then, not too long later, a defendant will file an answer. Sometimes they can get short extensions. But basically, in about a month or less, a defendant is going to file an answer. So once the defendant has filed the answer, then your fee for your lawyer is going to increase to 40%. So again, in higher value cases, that number goes down as the recovery goes up. But this is up to $1 million. So it's 33 1/3 before a defendant files an answer, or 40% after the defendant files an answer. But there is an exception where it wouldn't be 40% even after they file the answer, and that is if the defendant admits fault in their answer. Now, this person I was talking to last week said, well, the guy admitted fault, the other driver, the at-fault driver admitted fault at the accident scene and has told his insurance company that he's at fault. Well, that's a really strong case for thinking that your fee is probably going to stay at 33 1/3 the entire time. However, I have seen cases where there was an admission before the whole case, at the accident scene, and sometimes even to the insurance company, where still amazingly the insurance company denies fault. They can say, well, our client was just wrong. It really wasn't their fault. They were thinking it was their fault, but it really wasn't, because we've come up with this other evidence and it really wasn't. But so it's not what is said at the accident scene. It's not what an insurance company was told or told you or anything like that, because also insurance companies pre-suit have adjusters working on cases. Adjusters are not lawyers. So if the case goes to a lawsuit, then the adjuster is old news. Whatever they said is old news. They cannot make any promises. The defense lawyer who represents the insurance company and the at-fault driver is going to be, I want to say, driving the ship. They're going to be making the decisions. So we have to wait. We have to wait to see what the defendant says in their answer. And the reason that the fee goes up is because there's substantially more work involved if we have to prove fault in an accident. And that can encompass so many different levels of work and time required. But in the more serious the cases, the more that's going to be involved. But even a simple, what we see as a fairly simple accident case can get very complex as far as who caused the accident. It's really no more complex for a major serious injury case than it is for a simple case. I mean, fault has nothing to do with the seriousness of your injuries, which the seriousness of your injuries has a lot to do with the value of the case. I mean, fault does too. That's why we have to fight fault. But I'm saying the complexity of proving fault doesn't change based on the value of the case. So anyway, let me just simplify it again. 33 1/3 up to when the defendant files their answer. After that, it's 40% unless the defendant admitted fault in their answer, at which case it stays at 33 1/3, and all of this is up to 1 million. The other thing to keep in mind is that when the defendant files the answer, this is just the beginning of a fairly long process, at least a 1 to 2 year process with litigation. That it has many twists and turns, lots of different parts of litigation. It's a big job. It's a lot of things that you won't see. It isn't just waiting for a jury trial. We go through a long process called discovery, where we try to get information from the other side and they try to get it from us through a combination of written questions, admissions, depositions, requests for documents. And then we review all of those things, or maybe request more. We might file motions trying to get more discovery, that the defendant may object to providing certain discovery, and all these other things. Then we can file a series of motions contesting discovery or trying to get the case dismissed on various grounds, or the defense may try to do that. We may be fighting over expert admissions, the qualifications of experts, and they're just an enormous amount of rules and law that goes into handling a case before you ever get to trial. That's called pre-trial. So there's pre-litigation and then there's pre-trial. But pre-trial work can be extremely important and very extensive. So anyway, so when the defendant is filing their answer, that is literally just the baby stages of the lawsuit. So that's the time that this is determined. So if a year later the defendant finally says, you know what, yeah, I was at fault, which they won't do anyway, but if they did, it wouldn't change anything because we've already had to do the work, the enhanced work in proving fault. So, so we got, I think that's about it. But I forgot about the story about the 33 1/3. And this reminds me of kind of some things I've seen online. So this is a whole other really section of this. I've looked this up before to see what are clients seeing, and I've seen everywhere from 25 to 33%. In my experience, very, very few lawyers, I don't know any, and I know quite a few injury lawyers. I don't know any injury lawyers who are charging less than what I just described. It just really isn't a thing. But there have been a couple of limited exceptions I've either heard about or seen directly. The limited exceptions are I've seen people who are just getting started in injury law reduce their fee a little bit and advertise that for a short time and then stop doing that. I haven't actually seen that in a long time, but the rule is not a mandatory requirement. This is the maximum that lawyers can charge. But because the lawyers are taking a risk and not just with their time, but actually with their money, we have to spend money to prosecute these cases. Sometimes it can be a substantial amount of money. We just settled a huge case for $7 million, and actually the costs involved were $1 million, almost $1 million. So that money was all at risk. And every case is a business decision. The other thing is some people think, well, then I need to go to a bigger firm that has more resources and that kind of thing. And that's just faulty thinking. I've got some videos on that. I specifically addressing that question. But we have all the resources all of the resources that would be needed to prosecute the most catastrophic injury cases. No firm, no matter how large they are, is going to make a decision on a single case based on anything other than how much am I going to risk versus the potential reward. In other words, obviously we wouldn't spend $1 million on a case that was worth $30,000. It's all relative to the amount that might be recovered, and it wouldn't make business sense to do it any other way. But and actually my belief is that I don't know almost any firm that would have risked what we risked on this particular case, because there was a lot of risk that we wouldn't recover anything. Because the guy rear-ended the guy who recovered the $7 million did the rear-ending and some other complications with the case. I am planning a video on that, so please subscribe if you're interested in hearing that story. But I'm getting myself off track. The point is that most of the time, lawyers are not going to, I mean, I don't know any injury lawyers who are charging less than the going rate. I mean, because of the risk and because of the amount of money we have to spend, if you pay a lawyer hourly, they aren't taking any risk. They just get the money. That's actually how I used to work. When I was on the defense, we would get paid hourly. We charged huge retainers. Not me, I was working for a firm. I was making a salary. But the firm charged huge retainers, and then they would work off hourly. Okay, so let me tell you the story about the other situation I've seen where lawyers had in their contract that they were charging 33 1/3, and they didn't, there was nothing else mentioned. Oh, by the way, most of the time, if the lawyer tells you it's 33 1/3, then they might still make you sign a contract that has the breakdown of this rule. I'll hold it up to the screen. I don't know if you can see it. But you can see there's lots of, this isn't even the whole rule. It keeps going on for at least another page. But lawyers will have that exact breakdown in their contract. At least we do. But a lot of lawyers won't explain it when you're signing the contract. For a couple of reasons. Now, let me get to the 33 1/3. I keep promising, and I'm going to do it now. It was a client who came to us, who was a former client, who had previously been with what was, at the time, one of the larger firms in town. She was really unhappy with them. This happens a lot. She ended up coming to us, and I just happened to see the contract she had signed with the other firm. And I went down and read and saw that it was only going to charge 33 1/3. This is not any firm that you would be aware of because they ultimately went out of business. They were a huge firm, but they went out of business. So anyway, it said 33 1/3. And then I kept reading and it said this was all for pre-suit. So in other words, that means not pre-trial, not after they had filed a lawsuit and were waiting for trial, but pre-suit. They hadn't even filed a lawsuit yet. The fee was going to be 33 1/3. And then it basically said, that's it. We're only going to handle your case pre-suit, essentially. In other words, what they were signing up for was an agreement that they would never go to litigation. I cannot even tell you how bad of a mistake that would be if you have any kind of decent case, because the value of your case pre-suit is nothing compared to the value that you can, in most cases, depending on the insurance policy, but you're going to be able to get much, much more if you go through some amount of litigation. And so it would just be a terrible mistake to sign up with a firm that was only going to handle your case pre-suit. I don't know that that's common. I think it's more common that lawyers just aren't explaining that part of it. And then the question is, how far in litigation are they going to get? But just be aware that if a firm is just telling you they're going to charge 33 1/3, there's a big possibility that they're basically saying they're never going to file a lawsuit on your behalf. I'm trying to think. I just couldn't believe that. I couldn't believe that this size firm was just telling everyone that they were going to handle it they were just never going to file a lawsuit. The other thing is that the lawsuit really is worth it if you have a good lawyer and the lawyer determines that we should file suit. And there are just so many different scenarios where we play that out. If we think the case is worth the policy limits, we absolutely do everything we can to try to settle that pre-suit so that our client only has to pay 33 1/3. And, that's our goal. I mean, that's what we'd love to do. But insurance companies are making that so difficult where on a serious value case with a high insurance policy, they just won't settle the case. Or even on, a lot of moderate injury cases anymore, they just won't do it. And we have to file suit. But sometimes they will. frankly, if the insurance policy is low enough and the injuries are bad enough, then we hope that maybe they won't settle because there's something called bad faith, and I need to do a video on that, or we can try to get more than the insurance policy. So it does get complicated, but I think you just need to keep in mind that, I think it's important that your lawyer would break down all the fees for you. Because if they're not explaining in detail what fees you potentially are going to be facing, then what else aren't they telling you in your case? I hope this kind of illustrates the way we would handle a case. I have sat with many clients and explained the rules just like I'm explaining to you. Explained where they come from, explained the reason for them, explained why you want to pay them. And I'm kind of just scratching the surface on everything I could say about fees. But if you have specific questions about fees and you've been in a car or truck accident and you have moderate to severe or even catastrophic injuries, or you lost someone from wrongful death, then we would really love to talk to you. I think it would be in your best interest to talk to us. I truly believe that we are like a little known but seriously powerful weapon. I work with another lawyer, and together our strengths are second to none in my estimation. And so we would like to talk to you. We are no pressure. We're a small firm and a small business, but we will tell you exactly what we think about your case. We do a lot of things differently. I feel like we practice law the old-fashioned way, and you'll hear me say that a lot if you subscribe, which I think you should do, because if you're involved in this, unfortunately, you kind of need to understand the lay of the land, and you need to have a lawyer who's going to explain these kind of details to you and help you to understand what's really going to affect the value of your case, because the bottom line is, it's not so much what our fees are, but what are you going to recover in the end. And I think it would be a terrible, terrible mistake to assume that if you could just find a lawyer that charged a lower fee, you would get more money. I don't think that's even remotely true. We have been involved in many cases where we got substantially more for the case than a lawyer who the client terminated or early in the case and came to us, and what the other lawyer was able to do, or even what we know to be the going rate for similar types of cases. I would really love to talk to you, so I hope you will consider giving us a call just to talk about your case and see what we think. We'll give you our best opinion about what we think we can do with it, what potential problems exist, and how the most important thing is how can you maximize the value of your case. When you call, we will be focused on telling you the things we think need to happen in order for you to get the highest value in your case. And I think they'll make sense to you. It's like the rule. It just is. There's reasons why we do the things that we do to try to increase the value. And usually when our clients understand that, they do what we ask them to do as far as treatment and collecting evidence and that kind of thing to the extent they need to be involved. And they usually end up really happy. So I hope you'll give us a call, and I'm sorry you're in this situation. Take care.